This employment law video is on office relocations. Mobility clauses. If an office or part of it is relocating, it's important to see whether there's a clause in the employee's contract which allows the employer to change the employee's place of work. These clauses are known as mobility clauses. A very wide mobility clause purporting to allow the employer to change the employee's place of work to any location is likely to be unenforceable. However, a commonly used mobility clause allowing the employer to relocate within reasonable travelling distance would probably be acceptable. It will often come down to what the intentions of the parties were at the point of contract. Redundancy. In a redundancy situation, the employer could rely on a mobility clause in one of two ways. The employer could avoid the whole redundancy by simply asking the employee to relocate in accordance with the terms of the contract. If the employee refused, the employer could arguably dismiss the employee for misconduct on the grounds of a failure to follow a reasonable instruction. Remember though that the mobility clause has to be enforceable for the employer to be able to rely upon it. Alternatively, the employer could go down the redundancy route and offer the employee suitable alternative employment at the new location. If the employee refuses, the employer could argue that the refusal was unreasonable and that therefore the employee lost any right to a statutory redundancy payment. In some cases, it may be reasonable for an employee to refuse an alternative job, and the employee, subject to length of service, may then be entitled to a statutory redundancy payment. Unfair dismissal. Employees normally need to have at least 2 years continuous service with the employer to be able to bring an unfair dismissal claim. In order to defend the claim, the employer would need to show a fair reason for dismissal, such as redundancy or misconduct, and that a fair process had been followed. In a redundancy case, the employer must consult with the employee prior to any decision to dismiss. Depending on the number of employees affected, the employer could also have an obligation to consult the workforce collectively. The employer would also have a duty to consider alternative suitable roles for employees. Depending on the circumstances, the duty could extend to searching for companies within the same group of companies. If, for example, a London office was relocating to New York, it might be reasonable to look for suitable alternative roles within the New York office, as well as any other company offices. On some occasions, the employer may be required to carry out a fair selection process. This would normally be more relevant though, where the business was reducing headcount rather than relocating. That's my video on office relocations. The usual caveat is that this video is for guidance only and should not be relied upon for specific advice. For more information, do visit my website, and if you're interested in receiving notifications on other employment law videos, do subscribe to my channel.